Good afternoon. Please be seated. All right, we are on the record in 25 CR 03118. Mr. Fleming, good afternoon.
Good afternoon, Your Honor.
And Mr. Thompson, good afternoon, sir.
Good afternoon, Your Honor.
I understand this is on to address a warrant that has been issued in this matter, as well as to set a future hearing on the motion to dismiss. Before we address the warrant, we will take up the arraignment. One moment, please. All right. Mr. Thompson, would you like the opportunity to apply for court-appointed counsel in this matter?
No, I wouldn't, but I would like to let the court know that I'm here by special appearance challenging the jurisdiction of the court.
All right.
I've never been served anything related to this. Some documents were sent to an improper post office box. It seems to be the same improper post office box that I've seen Mr. Reineke mail things to. And it's not my post office box. I've asked for proof of service, as in that mailing should have returned to Mr. Fleming here to prove that it had been mailed, because I see no reason to believe that it had. So there's the lack of service. Then there's the warrant itself. The warrant was it's spatially incorrect. It does not follow bench warrant law,
right.
like usually they do. And it was also signed by a disqualified judge, which
right.
also invalidates it.
Mr. Thompson, what we're going to do is we're going to take up the arraignment, and then I'm going to address your release, and then we're going to set a future hearing to discuss all of the issues that you have raised here today. Okay. I saw that you raised those by written motion, and so they will be properly before the court once we set a hearing on those issues.
Okay.
So
one more thing that I wanted the court to see is this is a screenshot from a video of my wife being knocked to the ground on her bike by the victim in this case back on October 9th. Right. So how does he be able to do something like this? And I'm here facing something where absolutely nothing occurred.
All right. So, Mr. Thompson, we're going to take up the matters in the order that I laid them or set them forth. So the first thing we're going to do is the arraignment. And so you have indicated that you do not want to apply for court-appointed counsel. And, sir, have you been provided with a document titled Waiver of Counsel?
This thing right here?
All right. Yes, that's the document. And did you have time to review that document?
I've seen it before. I actually signed one the last time I came in here.
All right. For a different criminal matter?
For this, I appeared once before in this matter.
In this case?
Yes.
Before which judge?
Where was it? Oh, yeah. It was very quick, Judge Sikora.
All right. And I don't see that it made its way to the court file, sir. Did you sign it, and did you review it and sign it and provide it to the court?
It was handed to me on a clipboard. I signed it and I left it on the short wall there.
It's possible that it, well, I don't want to surmise what happened, but it's not in the court file. Are you willing to sign another one so that it can be, you have signed it?
Yes.
Madam Clerk, if you could retrieve that for me, please. Thank you. All right, Mr. Thompson, I'm going to go over these rights with you on the record. All right. So this document says, sir, do you understand that you have the constitutional right to have an attorney represent you? Do you understand that?
Yes, I understand that I have a lot of constitutional rights, very few that have been recognized.
All right. And do you understand that I would appoint an attorney to represent you if you qualify?
I do.
All right. Do you understand that the law considers you to be at a serious disadvantage if you proceed without an attorney?
I do.
Do you understand that maybe because you may lack legal training and experience and you may not realize defenses that are available to you? Do you understand that?
I understand that.
Do you understand that the rules and procedures of a trial will apply to you even though you are not a lawyer?
Yes.
Do you understand that the state, through the district attorney's office, will be represented by an attorney at all stages of the proceedings and will have an advantage over you?
No, I don't understand that.
All right. Do you understand that the state will be represented by an attorney at all stages of the proceedings?
Yes.
Do you understand that some may consider them to have an advantage over you because of that?
Yes.
Do you understand that you're giving up the following benefits by choosing not to have an attorney? An attorney could review the facts of your case to determine if there are defenses that apply or identify problems with the state's case. Do you understand that?
I do, and nobody can identify the facts better than I can.
Do you understand that an attorney could help you enter a plea, negotiate a plea agreement, and address your release before trial?
Yeah, I understand that.
Do you understand that an attorney knows how to gather evidence, file pretrial motions, call witnesses, and cross-examine the state's witnesses?
I don't think an attorney can do that any better than I can.
Do you understand that an attorney knows the rules of evidence, knows how to question witnesses and present evidence that may be necessary for your defense, and knows how to object to improper evidence?
That may be the case, but from my experience, attorneys often abuse those rules, and so I don't like to engage in that game.
All right. Do you understand that an attorney could help you decide if you should have a jury trial or have the judge decide the case?
I guess if you say so, I guess I do.
Do you understand that an attorney could help you evaluate and challenge potential jurors, make legal arguments to the court, and present opening and closing statements?
I would say yes.
Do you understand that an attorney can tell you what sentence may be imposed if you were to be found guilty?
I suppose, but I think that information is available.
Do you understand that an attorney can present evidence and make arguments about sentencing issues?
Yes.
Do you understand that an attorney knows how to gather information from the prosecutor that is important to your case, such as police reports and statements from witnesses?
Yes, but I believe I can do that as long as they're forthcoming with that information,
Okay.
which has always been a bit of an issue.
Do you understand that the judge, the district attorney, and court staff cannot give you legal advice or help you defend yourself at trial?
I do.
And are you under the influence of anything today?
I'm under the influence of false accusations by Mr. Fleming here.
All right. Are you suffering from any disability that affects your ability to make decisions?
No,
Are you thinking clearly?
I believe so.
Has anyone made you any threats or promises to have you waive your right to have an attorney?
No.
All right. Let's see. You have not checked the box whether you can read, speak, and understand English, sir. Are you okay if I check that box for you?
Sure.
All right. And you have signed this document. Is that your signature?
Yes, it is.
All right. And you've made a notation that you believe you are the victim rather than the defendant. I'll just note that for the record that notation has been made on this form. It is not dated. When did you sign this form, sir?
Just when it was handed to me just a while ago.
All right. Do you mind if I enter today's date?
Nope.
All right, Mr. Thompson, I have accepted your waiver of counsel finding it is freely and intelligently entered. As part of that waiver, it's important that I tell you that you have the right to receive all the discovery from the district attorney's office. Do you know how to do so?
I believe so. I've just requested it in the past, and
All right.
sometimes I've gotten things and sometimes I haven't.
Do you have any questions about that process for me today?
Well, I guess I'm anxious to see what the district attorney claims to have in the way of evidence, because I've looked at the paperwork from the court file, and from what I see there isn't any. I don't see any evidence, and I don't see any admissible evidence. I see evidence that was obtained from my private property without a warrant.
All right, well, sir, I'm not going to get into those. My question to you was, do you have any questions about the process on how to request the discovery?
No.
Okay. All right. Sir, we need to proceed forward with the arraignment. Do you have a document titled District Attorney's Information in front of you?
I do.
All right. Sir, you have been charged with 2 Class A misdemeanors. Under Oregon law, the maximum possible penalty is 364 days in custody and a fine of $6,250 on each offense. You have the right to have me read this document to you aloud in open court, or you can choose to read it silently to yourself. What would you like?
I have read it.
All right. Would you like me to read it aloud, or are you satisfied?
I'm satisfied.
All right.
Yeah.
And sir, your name is set forth on that document. Is your name correctly set forth?
Yes.
And is that your true date of birth?
Yes, it is.
All right. So you have a number of rights in this matter. You have the right to remain.
My weight is wrong, by the way.
Okay, duly noted. Would you like to change the weight, Mr. Fleming?
I'm more like 170.
That's fine. We can amend through interlineation here.
All right. 170 is the correct weight, sir?
Yes.
All right. We'll make that adjustment. Thank you. All right, sir, you have the right to remain silent about the facts and circumstances of your case. Anything you say can be used against you. You have the right to an assistance of an attorney at all stages of the proceedings, including deciding how to plead to the charge. You have the right to have a court-appointed attorney if you qualify and cannot afford to hire an attorney without substantial hardship to you or your family. You have the right to have a speedy and public trial by a jury of citizens from the community who would decide whether or not you are guilty. You have the right to confront and to question under oath or cross-examine each and every witness called against you. You have the right to compel witnesses to come to court by subpoenas issued by the court clerk or by your attorney. You have the right to review and to obtain copies of the records written in your case or the discovery. You have the right to testify at your own trial, or you may decide not to testify. If you decide not to testify, the judge would instruct the jury that your decision not to testify may not be used against you in deciding a verdict. And you have the right to have the state prove each and every criminal charge against you beyond a reasonable doubt. All right, sir, now we are going to address the warrant. I'm going to hear from Mr. Fleming.
And Your Honor, we can recall the warrant since Mr. Thompson appeared in person here. As far as release, the state recommends a conditional release, conditions of obey all laws. No contact with named victim Robert Kim Reed or members of his immediate family. Donna, Bob, Karen, and Casey, I believe, would be those family members. Or the property at 50900 Maston Road in Lapine, except the defendant can still use the easement on that road to access his own property, which
I object to that comment, Your Honor.
adjoins.
Go ahead, Mr.
Okay,
Fleming.
which adjoins the Reed property. They are neighbors. Other than that, nothing to add, Your Honor.
All right, if you could list the family members again, you're asking for the no contact provision. I got Robert and Donna.
I believe the family members, so Robert Kim Reed is the named victim. Immediate family members are Donna, Bob, Karen, and Casey. I think it covers immediate families. That's the immediate family.
All right, and the address one more time, 50900, is that it?
Yes, 50900 Maston Road in Lapine, Oregon, except with that caveat about using the easement.
I have some comments regarding that, Your Honor.
Yes?
There
sure.
is no such thing.
Mr. Thompson, one moment. Everybody has a turn to speak. Mr. Fleming, did you finish your recommendation?
That is my recommendation. I think.
All right, now it's your turn, sir. Go ahead.
Thank you, Your Honor. As you're well aware, the big issue here has nothing to do with all this little peripheral stuff. This has to do with not the easement. It's not the easement. The easement belongs to my wife and I and nobody else. It's an exclusive easement until anybody can prove otherwise. Anybody who is on it is trespassing, as the victim here was for this alleged event, which was a non-event, which has no evidence. So in order for there to be no contact, then the non-easement holder should not be on the easement. They should use their other original driveway, which they can do. They don't have to be on our easement. We don't want contact with these people. We don't have any choice. It's how we get home, how we come and go. So any kind of non-contact should involve them staying away from our easement. We have a quiet title action filed. I don't know if you've seen that, but that will settle all of this. And it can only be settled one way, the wording on the deeds. So that really resolves all of this stuff. Even this matter shouldn't be going ahead until it's just clearly established by the law, by the wording of the deeds, who has the right to the deed. We have the right to a deed. They have a duty to leave. We have the right to the easement. They have a duty to leave the easement alone. And that hasn't been happening. And that's what needs to happen.
All right. Understood. Sir, as it relates to the conditions of your release, the district attorney's office has asked the court to impose a no contact provision with the named individuals that you heard from the prosecutor. Any reason you cannot abide by that condition?
Well, I certainly see conflict, unavoidable, if these people are going to be running rampant on our easement. What are we supposed to do? If we see them out there, we turn around and go home. This isn't a driveway. It's an easement specifically for roadway purposes. And we're the only holders of that easement. So
right.
how do you resolve that?
Are you able to not have contact with those individuals?
Well, that would be very difficult. If they stay away from our easement, it's easy. There's no contact. We can come and go. They can go on their own road.
All right. Mr. Fleming, I think it's prudent to be clear in this no contact provision, and so that there is no confusion moving forward. You have indicated that the state does not have an objection to Mr. Thompson continuing to drive upon the easement. And so how does that square with the no contact? I just want to be perfectly clear on this record as to what the expectation is.
And Your Honor, I think the expectation here is that Mr. Thompson can use that easement as he typically would. Seems like an easement for ingress and egress over a piece of property. That's fine. I don't want any verbal contact, electronic communication, in-person contact. Obviously, they're neighbors. Just like this happens with neighbors who live 20 feet away, certainly will come to pass that Mr. Thompson will come into visual and physical presence of Mr. Reed and vice versa. That's not a problem for the state. Passing them on the easement or on the roadway, not a problem for the state. It's if that becomes a voluntary interaction where Mr. Thompson engages with Mr. Reed and anything more than just passing by him. The issue here, Your Honor, just so the court knows, and I think the court does have a good idea, there's a dispute between these folks. It seems the temperature's gone up on that dispute in recent months. The state's concerned about that temperature getting higher. We'd like to bring it down. That's the goal of this.
All right. All right. So, Mr. Thompson, I will recall the warrant that was previously issued in this case. You will be authorized a conditional release. You are ordered to obey all laws. You are to have no contact with Robert Kim Reed, Donna Reed, Bob Reed, Karen Reed, or Casey Reed. That no contact provision is no in-person contact, no electronic communication, no third-party contact. You may continue to use the easement as it is your ingress and egress to your home, as the district attorney has stated. So the no contact provision does nothing to interfere with your ability to come and go from your home. You may not engage with the Reed family in doing so. Do you understand?
I have no desire to do so, nor have I had before.
All right. You are to have no contact with the address of 50900 Maston Road in Lapine, but for the coming and going to your residence as we have described. Understood?
Understood.
All right. We will set this for a hearing on the motions that have been filed. This court has room this Thursday at 3 p.m. If that works for the parties. Mr. Fleming?
It works fine for me, Your Honor, if we're talking about the motion to dismiss. I think there have been some subsequent motions that are filed.
I think there's two motions to dismiss, maybe?
I think there are two motions to dismiss. You can probably deal with both of them. There's a third motion that's more evidentiary in nature, which I think probably we can wait to set a future date on that.
Let's see. If you wouldn't mind looking at, I only see
And that's
the
fine, Your
motion to
Honor.
dismiss for lack of jurisdiction.
I
and
think
a-
it's in,
Your Honor, Ron has a conflict that day in Pine.
What's the day we're talking about?
I think it's,
Thursday, traffic,
Oh,
so just,
and Your Honor, I think it's styled as a motion to dismiss for insufficient evidence. It's actually an evidentiary motion.
What was the date that was filed?
And it's just kicked me out, so let me get back in here. That would have been filed, I believe, on the 24th of February in the court journal.
All right, let's just be clear about this. So there was a motion filed February 24th. No, excuse me. A motion filed February 19th. Motion to quash warrant. That warrant has now been quashed. And motion to dismiss charges. We have not addressed the motion to dismiss as part of that filing. So there's a February 19th filing that needs to be set. There is a February 24th motion to dismiss all charges based on insufficient admissible evidence. And Mr. Fleming, it's your position that is an evidentiary motion that is not ready to be heard.
That is, it appears to be an evidentiary motion. It seems to be relying on citations to rules of evidence and perhaps some sort of constitutional foundation. So I would take it as an evidentiary motion, not purely legal argument.
All right, and so the state has not had adequate time to respond to that motion?
That's correct, Your Honor.
All right, and then we have a motion to dismiss filed February 28th, motion to dismiss for lack of jurisdiction. Mr. Thompson, do you believe those are the three motions that you have filed before this court?
I believe so, yes.
All right, why don't we look for a date 30 days out to address all of them together, and so we're not doing this piecemeal.
That would be fine, Your Honor. The state
All right,
would
so
be
the
fine with
state
that.
has adequate time for response. This case has not been specially assigned to this court, and so I don't know how that will be docketed. Just, I know there was some confusion at the last minute today, whether this court was going to hear the matter or not. I don't know, Mr. Fleming, if you have any insight into that or if you know as much as I know, which is exactly nothing.
I certainly don't have an objection with Your Honor keeping this matter in front of this court, but
To be clear, that's not a choice I get to make.
I understand that, Your Honor.
It is.
If Your Honor perhaps converses with the PJ and decides on that in the coming days, just to let the court know, I have no issue with that. I know there have been 3 motions to disqualify judges filed. I would have a problem with the court granting all 3 of those based on the statute, because I don't think there's a basis to grant more than 2. But it could become a problem finding judges to hear this if it's left on the normal calendar.
Mr. Fleming, how long for these motions to hear all 3?
I would guess 2 hours would be my best estimate, I think. I don't think we're talking about a half day. I don't think it needs to be on the trial docket.
I'm optimistic the parties could do it in 1 hour. Mr. Thompson, how long are you requesting for these 3 motions? Maybe 90 minutes?
I would think 1 hour would be sufficient.
That being said, Mr. Fleming, I have not looked closely at these motions, and if you believe they're evidentiary in nature and you're going to be calling witnesses, we can give you the 2 hours.
I only think I'd be calling maybe one witness and very briefly for the evidentiary motion, so I would say
All
1
right,
hour.
Madam Clerk.
1 hour should probably get it done.
Let's see if we have 90 minutes at a 3 o'clock time, and we'll do our best to avoid any conflicts. At this point, it hasn't been assigned to me.
Finding 90 minutes will take a little longer, Your Honor, just I need a few seconds. Oh, here we go. We can offer March 18th at 3 p.m. We have 90 minutes earlier.
Let's go 30 days from today's date, if you wouldn't mind.
On the CC1 calendar, 30 days from today, it's in Judge Miller's, and he's been DQ'd.
All right. Who has the next rotation after that?
Next rotation after that is Judge Sakara.
All right. So the 2 judges that are on that rotation in the 30 days are Judge Miller and Judge Sikora, both of which are subject to the first 2 motions to disqualify. So, and then after that rotation, Madam Clerk?
After Judge Sikora, we have Judge Emerson, and then we're talking from sort of the second week of May.
All right. What time do we have on that docket? Oh, a trial 3 rotation. Okay, let's try that date. April 21st at what time? 8:30. 90 minutes. April 21st, Mr. Thompson, at 8:30.
Sounds fine to me.
Do you want to check with Mrs. Thompson? I know that she's often dialed at the dates. Mr. Fleming?
That works for the state.
All right, and Mrs. Thompson gave her acknowledgement. So, sir, we'll have you back April 21st at 8:30, which will be the 3 motions that I have identified. The motion filed February 19th, the motion filed February 24th, and the motion filed February 28th. That will be a 90-minute hearing set that date and time. Mr. Thompson, before you leave court, we'll have you sign a release agreement that outlines the no contact provision that I have ordered in this matter. Do you have any questions?
My only question, Your Honor, would be when can I get discovery? Like anytime now?
Yes, it should be made available to you. We've accomplished the arraignment, and so you should be able to retrieve that from the district attorney's office directly next door.
Okay.
Mr. Fleming, any
Thank you.
reason that's not the case?
Let me take a look to see if it's prepared. When it's we'll have to prepare it in physical form.
There's time, so it doesn't need to be today.
I'll have my legal assistant prepare it. I'd suggest perhaps coming to retrieve it tomorrow or the next day, but we can send him an email.
All right. I'll trust, Mr. Thompson, that you can work with the district attorney's office to retrieve that. I think that there needs to, I'm thinking through the no contact provision. It seems, Mr. Fleming, that there should need to be an exception for third-party contact to their counsel, given the legal proceedings that are simultaneously being heard in these folks.
That's fine, Your Honor. I certainly wouldn't intend it to prevent, I understand there's ongoing legal proceeding. I wouldn't intend to prevent those proceedings from moving forward in the normal course, nor do I think legally could it. So I have no problems with the court putting that.
All right, I just want to be
into the-
clear about that. You can still have contact, electronic communication with Mr. Reinecke or any other counsel that is involved in these proceedings. That would not violate the no contact order,
Okay.
as long as it is surrounding a legal process. Understood?
That's all they were.
All right. Okay. And Mr. Reed, did you want to be heard today in this as it relates to these proceedings? All right. All right. Then, sir, we'll have you back April 21st at 8:30. And Madam Clerk, do we have the release agreement?
I do.
Oh, great. Before you leave, you'll sign that. All right. Thank you. All right. Mr. Fleming, anything further?
No, Your Honor.
All right, court will be in recess.
Thank you.
Thank you, Your Honor.